This is 180 seconds of what you need to know from the world of litigation and investigations. Let's waste none of your precious time. This is Disputes 180. I'm delighted to be joined by my colleague Oliver Browne, who is an expert on today's topic, the new Arbitration Act. Over the past decades, London has established a reputation as a world-class arbitration centre. But this is a competitive global market with many keen and determined players. So why did we need a new Arbitration Act, Ollie? What changes has it brought?
Thanks, Stuart. The 1996 Arbitration Act was a landmark piece of legislation which modernised English arbitration law, enshrining principles of party autonomy, limited court intervention and procedural flexibility. And for nearly 30 years it helped make London a leading seat for international arbitration. But the rest of the world moved on, and other jurisdictions have updated their legislation, which, together with evolving commercial needs, prompted a review. The Law Commission launched a consultation in 2021 and concluded that while the 1996 Act worked well, targeted reforms could strengthen clarity, efficiency and fairness. The result is not a wholesale replacement, but an amendment act, which updates and improves the 1996 Act while keeping its core structure intact. The new Act is now in force, but the changes it implements are expected to become effective later in 2025. So what's new, and why does this benefit London-seated arbitrations? First, summary disposal. Arbitral tribunals now have express powers to summarily dismiss unmeritorious claims or defences, which streamlines proceedings and aligns with the way English courts operate. Second, an arbitrator's duty of disclosure. The new Act codifies an arbitrator's ongoing duty to disclose any circumstances that might reasonably give rise to doubts about their impartiality, reflecting UK Supreme Court guidance. Third, the governing law of arbitration agreements. There's now a clear default rule that the law of the seat governs the arbitration agreement, unless parties expressly agree otherwise. This brings clarity to a previously unsettled area of law. Fourth, challenging jurisdiction, the no-waiver rule. Parties no longer risk waiving jurisdictional objections by engaging with the arbitration, provided they raise those objections at the appropriate time. And lastly, emergency arbitrators. A notable addition is an express provision for emergency arbitrators, giving parties access to urgent interim relief before the full tribunal is in place, aligning English law with international norms. There were some proposals which didn't make it into the Act, such as a statutory guarantee of confidentiality and a mandatory appeal mechanism on points of law. But the amendments very much strengthen the 1996 Act and will maintain London as a leading and competitive seat for international arbitration.
That's great. Thanks, Ollie. These are certainly important things to be considered when choosing where to arbitrate. You'll find lots more detail on the new Arbitration Act in the resources below. And if you'd like to chat about what this might mean for you or a dispute you're involved in, do get in touch. And that's your 180 for today. It was brought to you by the wonderful team here at Paul Hastings in London. If you want to join a live version, we host regular events at the Paul Hastings office, including our two flagship series, Developments in Disputes and The Future of International Arbitration. To make sure you don't miss out on any of this great content, follow our Paul Hastings LinkedIn page. And if you've enjoyed this edition of Disputes 180, why not look out for the next one? That way, you'll have done a full 360.